Hi everyone, you're watching the virtual amicus and I'm Jay Ludha. So today's topic would be on the difference between cancellation of bail and setting aside of a perverse order granting bail. Yes, these two are different, but what are the differences? So we all are aware that every time a bail application is listed before a court, it could be the sessions court or the high court, there has to be striking of balance between a rights of an individual and two interests of the society. Because after all, bail is the rule and jail is the exception. But what are these circumstances in which this power of cancellation of bail can be resorted to? So is it done on the basis of merits of a case when the order that is granting it is perverse, passed without application of mind or any violation of substantive procedural law? Or does it happen when the liberty that is granted is misused or other such certain supervening circumstances? Now, the court that grants the bail, is it necessary that it is the same court that has to reject it, or it could be done by a superior court? What do you mean by a perverse order? And when is it challenged, and under what section of the criminal procedure code is it challenged? So we today decided to seek assistance from a very promising young lawyer who has made a name for himself in a very short span of time. Today we are joined by Mr. Siddhant Sharma from Delhi, and he's majorly practicing in High Court, then before Honorable Supreme Court of India, as well as doing trials in District Court. And just to give you all a brief introduction about our amicus for today's session, Mr. Siddhant Sharma, he studied law from Campus Law Center, Faculty of Delhi University in 2015, subsequently started his practice. As far as work experience is concerned, he's working as a senior associate in the chambers of Shri Karan Bhario. And prior to that, he worked in the esteemed chambers of Shri KTS Tulsi, senior advocate, where he also drafted and argued the appeal in the famous Arushi Talwar murder case before the Honorable Supreme Court of India, which was the appeal against the acquittal. Prior to that, he's also been an associate and worked in the chambers of Mr. Jaspreet Singh Rai, Advocate, Honorable Supreme Court of India, where he also assisted the court in Nirbhaya rape case, which was Mukesh Kumar and others versus NCT of Delhi at the appellate stage before the Honorable Supreme Court, where he represented Ms. Asha Devi, the mother. Prior to that, he also worked at lawrato.com for a period of 1 year. And he has a number of landmark judgments to his name, one of them being a very important issue that was settled by the Honorable Supreme Court of India that had upheld the judgment in the Honorable Delhi High Court, which was about how a widow's right to compensation or widow's right to claim compensation for the death of a husband will not abate on remarriage. And hence, she was entitled to equal share as parents. So he had put in appearance on behalf of the widow. So, and there are a number of plethora of judgments to his name. So thank you so much, Mr. Siddhant, for taking out time on a Friday evening. And so the stage is set. So today we decided to have a Q&A session with him because he's our expert. So any introductory remarks before we start our session?
Thank you for such a generous introduction, Jay. I think we should just begin with it. And you've made me short of words to introduce. You have introduced everything, so I don't think so anything else is required here.
So let's quickly start with our Q&A session. Question number one, Mr. Siddhant, when you talk about a perverse order, what do we mean by it in strict legal terms? When is an order perverse?
See, when the trial court or the high court neglects the evidence on record and passes an order, that order is known as a perverse order. Without appreciating the evidence on record, the nature of the or seriousness of the crime, and the court using its discretion grants bail, that is a perversity. That order is to be challenged. You need to go through it like under section 437 or 439 of the CRPC. You just have to read it out, read the order word by word, not just a glimpse of it. And that is when you would know whether the order of a bail is perverse or not, whether the court which has granted bail has exercised its correct jurisdiction, its correct discretion or not.
So coming to our next question, what is the difference between cancellation of bail and a rejection of bail order? If you could elaborate.
See, cancellation of bail is in a very simple word, we say when you can get a bail cancelled. So when there are plethora of judgments where the courts have regularly upheld, and even elaborated when you can get a bail cancelled. It is a very fine line. So there are 5 or 6 stringent factors which the courts have regularly held, that what are the considerations while granting bail and when you can get it cancelled. So if you do not look into the nature or of seriousness of the offense, the character of the evidence, or whether he will run off and do not come for a trial, then you can say the impact that his release would cause on the society. These are the cancellation of bail, where the court sees while giving you a stringent order that whether you can come further and seek for cancellation or not. On the other question, where you asked me for the difference, is when you can what when can you challenge the perversity of the order, right? So in the perversity of the order is when the trial court or the high court neglects all these evidences which the police have collected against the crime and grants the bail. So without or you can say an unreasoned order. So the Justice Chandrachud have always emphasized, when you are granting bail to an accused, you need to give reasonings. Why are you granting bail? See, bail is a right and jail is an exception. But when do you have to grant bail and how you're granting bail, you need to explain that in the order. Just stating one line that you're granting bail without appreciating the evidence is perversity of the order. So there are a lot of judgments. In the end, I can even share the names of the judgments where these differentiations have been discussed thoroughly. So I'll only give you the latest judgments. You don't need to go as back as it is. So these, and like from 2018 onwards, I can give you a lot of judgments where this has been a hotshot topic these days in the Supreme Court, because the high courts and the trial courts have been granting bail without appreciating the evidence, and the person, or you can say the victim, the complainant, or the relatives of the deceased, they have to face the consequences. So this is very important, where Supreme Court have regularly said that you have to give reasoning, or it is an adverse order or a perverse order.
Thank you so much there. So coming to our next question, uh, is it the same court that has granted bail can cancel the order, the bail that was granted, or is it the superior court that has the power to do so?
It is only the superior court which has the power to cancel or reject the bail orders. So in my, I'll share an experience of my own case. So it is a reported judgment, Mahipal versus Rajesh Kumar and others. So what had happened is the trial court, it is rejected the bail application of the accused under section 302, and that order was around 18 pages, the bail rejection order. So they appealed against that order in the Rajasthan High Court, uh, and while granting bail, the Honorable High Court only gave a one-page order granting bail to all the 5 accused. So one accused got bail, saying that I'll not go into the crux because it doesn't look nice. So it just gave them the liberty, and under section 302. So the client approached me asking about challenging the same order before the Honorable Supreme Court. Should we go or not? Because it was a young army man, a 19-year-old army man who had come back, and it was a highlighted case in Rajasthan also. So it was a very good order, basically, to be challenged before the Honorable Supreme Court. So I drafted it, I argued the matter, and Justice Chandrachud gave such a wonderful judgment in this, where he discussed the entire thing. And he again clearly said that this is an order which has been passed without any mind, and the high court or the trial court should have applied its own mind before granting bail to the accused. So it is only the superior court who can reject the or cancel the bail orders. It is not the same court which can override it order.
So, what were the main grounds that you had taken before the Honorable Supreme Court? What were the submissions that you had made, knowing that a High Court judgment or a High Court verdict was under challenge before the Honorable Supreme Court?
So basically, what had happened in that case was the High Court just said that it was a road accident. It took the pleadings of the learned counsel of the accused. He just submitted that it was a road accident and the accused had no role to play. And he never heard the other side. So the order never spoke or even mentioned anything about that. And he granted bail. So my argument was there were 36 antemortem injuries. 36 antemortem injuries right on the face, like you can make it out through the postmortem. And then there was this judgment, uh, Prashanta Kumar Sarkar versus Ashish Chatterjee. It is a 2010-14 SCC 496, which clearly mentioned the extraordinary jurisdiction or the discretion of the court while granting bail. When can a court exercise its power to grant bail in such heinous crime? One of the prime argument was the 36 antemortem injuries. Besides that, my other main argument was that the brother of the victim, the deceased, was also murdered during this process through a road accident when they were all on bail, when they were all not arrested. So this was another major ground that the accused was tampering with the evidence as well and killing the witnesses in this. They also approached one of the eyewitnesses. So these were the main grounds with the judgments. While I was arguing that matter, Justice Bhanumati had just passed a judgment on that, which was Bharat Bhai Bhima Bhai Bharwad versus State of Gujarat, which is a 2019-10 scale 138. So I produced the judgments, and I was, I guess, very liberally heard by Justice Chandrachud for a good 30-40 minutes, and we could get what orders we wanted in such a matter by getting them behind the bars again.
So coming to our next question, does the Superior Court, the Appellate Court, appreciate evidence, or does it take evidence into consideration while deciding on the cancellation of bail, or is it only when a prima facie case is made out, or in such cases that the court would intervene?
See, as you know, Supreme Court doesn't intervene under 136. So we just get a very limited time to convince the lordships behind. So they were pretty well convinced when I read the orders of the High Court and I read the orders of the trial court. And they were pleased to issue notice. And once they were pleased to issue notice, and then they heard me in length. And the main thing was the state never approached for cancellation. So they were even more inclined to hear me out and get the bail orders, the perverse bail orders cancelled, basically.
Now coming to our next question, in absentia of a specific application with respect to cancellation of bail, can the court suo moto take cognizance and issue orders with regard to cancellation of bail, or a specific application has to be moved under the criminal procedure code?
See, there's no specific as such as like the honorable courts can suo moto take any cognizance. You know that. So any person who's practicing would know that. So it should come into the eyes of the court basically. But where the victim or the complainant has suffered so much, they usually prefer an appeal before the High Court, the Sessions Court, or the Supreme Court. They file in an application because it's better to move in an application, because sometimes the courts are unable to grasp so much of what do we say, mm, like we have so much of crimes going on, so the courts cannot have a track on each and every bail order. So it's better to challenge it and get an order from the superior courts.
Great. And talking about limitation, does it come in the way of filing of an application for cancellation?
No, no, it doesn't.
It can be filed at any given point of time. The
It
moment
can be, but it's always better. It's always better to file it in an appropriate time. Otherwise, you'll always you have to give the you have to file a condemnation of delay application, and you'll have to first justify the delay. Why is so much of delay? So as it is said that even a small three days delay in filing of FIR can also get your case tossed up the other side. So it's the same way. The courts can go on the and grill the lawyer a lot when there's such a huge delay in such. So if there's a genuine reason, then even the courts appreciate. But I personally feel that there should not be a lot of delay, and we should file it within the limitations.
So is there a straight jacket formula, or are there certain conditions that the Honorable Supreme Court or guidelines that the Honorable Supreme Court has laid down in matters pertaining to cancellation of bail that A, B, C is the requirement, and in such cases only, in circumstances only, cancellation of bail order can be passed?
Yeah, it is a very well settled consideration. As I just spoke about that Bharat Bhai, Bhima Bhai, Bharwad versus State of Gujarat, Justice Bhanumati in para 10. I'll just read down the para if you want so. It is well settled that the consideration applicable for cancellation of bail and consideration for challenging the order of grant of bail on the ground of arbitrary exercise of discretion are different. While considering the application for cancellation of bail, the court ordinarily looks for some supervening circumstances. So the word supervening is very important here, which are tampering of evidence either during investigation or during trial, threatening the witness, the accused is likely to abscond the trial, or the case is getting delayed because he's not appearing before the court, or he's the bail which has been granted is being granted illegally. So these are the these are the factors which the courts consider, so which is very important. These are the guidelines which you'll find in a lot of cases being repeated time and again.
Yes. So coming to our next question, what do we mean by non-application of mind in an order granting bail? What is the Honorable Supreme Court in that case, refer to?
See, not appreciating the evidence is basically a non-application of mind. So if someone, for example, the accused has filed a bail application, so the accused will never give you the entire details. So it is the duty of either the complainant counsel or the public prosecutor, either ways, who is representing the complainant here or the victim here, to give a fair and give a fair trial basically, or give everything or put it in front of the court that the bail application which has been filed are having a suppressed facts. There are documents which are pending. There are post-mortem. See, the accused cannot get hold of a lot of documents, and accused will only rely on the documents which are in his favor. So being the counsel for the complainant, you are duty bound to produce all those documents, convince the court that he is not entitled for bail by providing him all the documents, providing the court with all the relevant facts, the correct facts, and the correct documents, showing the seriousness of the crime, or whether he can flee the country, or any other circumstance which are important for his cancellation of bail. So you will have to bring those records in front. Otherwise, the court will grant bail to him.
Coming to our next question, can such orders be passed ex parte, or the counsel for state or the counsel for the accused? The courts try and hearing them as well before passing such orders? Because ultimately it is with respect to a person's life and liberty.
See, usually, if I like what limited practice I had here, so I have always I've appeared on both the sides for the complainants as well as the accused. So here, when I've appeared on behalf of the accused, the PP, here we have public prosecutors. So the court always gives them a chance to rebut my application, or the IO rebuts, files a reply to my application, or what we here in Delhi call it a status report. Uh, so they file it, and on the basis of that, the public prosecutor argues the matter, and then it is, as everyone knows, it is the discretion of the judge to uh, grant bail or not to grant bail. Same in the High Court, we have additional public prosecutors, and in the Supreme Court, we have counsels from the state who represent. So once notice is issued in Supreme Court, the counsels from the state do appear, and they also argue the matter.
Right, then that pretty much sums up our session. Anything that I missed out and you wish to say, that anything that we haven't discussed or anything that I probably left out towards the end of our
Not much, because this is a very small topic, but a very interesting topic, and moreover, the discretion or the difference is very important to be understood. Not all orders are perverse, and not all orders can be challenged. See, you can challenge all the orders, that is not a problem, but whether you have challenged that in a right frame or not is important. So this session is more on for the complainants or the victims, not for the accused, basically. So this session for them is important to know when to challenge, or when to challenge the orders which are perverse, or whether the accused has taken advantage of the liberty given to him on bail. So has he gone on to temper some evidence, or basically has gone on and meet the complainant or any of the witness, or is trying to temper them, bribe them, anything. So these are things which needs to be taken care of, and once you have that fine line very clear in your mind, I think this should not go off your mind that quickly.
All right. Any landmark judgments that you wish to quote to all the viewers who are watching? Any list that you wish to provide?
I can quote. I've quoted a couple. One was the Bharat Bhai. Then, to start with, in this, one should always read the Prasanta Kumar Sarkar judgment, which is a 2010-14 SEC 498, 496. Then Anil Kumar Yadav versus State 2018-12 SEC 129. There's this latest judgment on this, which is State of Kerala versus Mahesh. It is a 2021 SEC online SC 308. So this is by Justice Indra Banerjee and Krishna Murari, Justice. This judgment also refers to the judgment I argued, Mahipal versus State of Rajasthan. And then there's another judgment. These all are latest judgments, which is Prabhakar Tiwari versus State of UP, which is 2020-11 SCC 648. This also covers Mahipal, discusses Mahipal. And then Mahipal versus State of Rajasthan, or you can say Mahipal versus Rajesh Kumar alias Polia and others, is 2022 SCC 118. So before reading all these judgments, you need to read the Sarkar judgment, which will clear all your doubts. There are more judgments on this, but if you read Sarkar, if you read State of Gujarat, and then the three judgments I have provided to you, that should clear all your doubts on cancellation of bail and the perversity of an order. When can you challenge the perversity of an order?
Before we end our session, just a question on a lighter note. You worked with such esteemed chambers before you went independent. Any lessons that you've learned, or any guidances that you wish to share that you've learned from such stalwarts that you've worked and assisted?
So I'll go. I've not worked in a lot of offices there. I've learned everywhere. I have learned something. So when you go out of, so let me start with my first job. So it was Lorato.com. So when you freshly graduate, you are desperate to have an office or have your own income. So Lorato.com was the first office, which was more of a startup. I learned how to speak there, because once you how to speak with a client, how to speak to an individual, how to speak to big corporates. When you get out of the college, you don't know these basic things. You are with the OER and all that basic all student life things which you have to leave behind. And I've I've been a professional cricketer myself, so dedication and hard work has always been there for me. Touchwood, which had no problem for me. Then I came to Mr. Jaspreet Rai's chamber. So there I learned, go fearless. You if you are unprepared or you are prepared in your brief, you have to go and be yourself and be fearless. Don't get scared. See, you if you know you're giving your best, there's see you cannot decide a judgment, but at least you know that you have given your 100%. I learned how to argue there in bail matters and everything. And I'll thank all my seniors here. They have always pushed me to do my own matters. They always wanted me to do my own matters, irrespective of what. That go argue yourself. Don't and argue and read. They always used to say read as much as you can. All the judgments, keep reading them. Then with Mr. Tulsi, I learned how to be calm. He, as a gentleman of that stature, he is very calm. So sometimes you're short of words with such beautiful people when you work with. So he's one kind of a person who has always pushed me with his esteemed what do I say? I am actually, when it comes to Mr. Tulsi, I go short of words. So he's that kind of, he has that kind of an aura and a personality. And and with Mr. Bharyok, he's like an elder brother. So he also pushes me to do my own matters, and I have that liberty. I've done all these matters here in the chamber. So he also, see, one thing which all of them have told me is read. That is how you'll improve. Without reading or without improvising, there's no your future is not very bright if you don't read in this profession. And make good to people. Basically, this is what they do.
Fantastic. So the other day we were doing a segment, and we discussed and highlighted the importance of finding a mentor and a professor in a law school, in college. And I think today, after the session, you made all of us realize, and to all the viewers who are watching, the importance of finding a mentor in a senior once you land up in the legal profession. So a mentor should always be there to look up to seek guidances from, because that is how you'll seek the right assistance, the right guidances. The lessons that they've learned over the years will help you build your practice. So on that note, I think that pretty much brings us to the end of our session. So thank you so much, Mr. Siddhant Sharma, there, for taking out time.
Thank you, Jeff. Thank you so much for inviting me for your virtual amicus. It was an honor being here.
My pleasure, and hope to see you again on another segment. So thank you so much to all the viewers, and stay tuned. Next episode is on its way. Please like, share, subscribe my channel. Stay home, stay safe. So it's goodbye for now. Thank you, Mr. Sharma.
Thank you.